let's talk about the impact that these proposed reforms are going to have on the various company stakeholders. And by that, I mean directors, creditors, employees, liquidators as well. We can't forget our friendly liquidators. So perhaps we can break it down and look at those various stakeholders and the two primary aspects of the reforms, which is the debtor in possession model and the simplified procedures for a liquidation.
That's right.
So most of what we know comes from the fact sheet, which was released, and of course the bill, and we're still waiting on those regulations. Some of the takeaways really, the real takeaways is how it impacts directors and office holders, who they're the decision makers in terms of the debtor in possession model, and the director remains the decision maker during the restructuring process, which is a huge difference from the current 5.3A provisions in the Corporations Act.
Absolutely. So, I was just going to say, and I think it's really important, a lot of the commentary that I've heard recently is that certain groups are worried that directors will be sort of not coerced, but sort of recommended to go into these restructuring regimes without fully understanding the implications that it might have for them and the business. Because obviously wanting to restructure is one thing, but putting the company into a formal regime to restructure is a little bit different. And I don't know, Stacey, do you know sort of some of the more pertinent implications that might be for the companies in this regard?
Yeah, well, I mean, there's lots of positives. The key negative, and perhaps we, as advisors, we have to make sure we're educating our small business clients, our individual office holders and stakeholders about what the effect of this is. So directors need to know that proposing a restructuring plan is in fact an act of insolvency. So that's going to come under the new Section 455 capital A. So it's similar to those familiar with Part 9 in the Bankruptcy Act. It's the same as an individual executing what we call a Section 188 authority and putting forward a personal insolvency agreement. So the director, by proposing one of these restructuring plans, has actually triggered an insolvency event for the company. Now, presumably, there's a balancing act when it comes to whether or not he should or she should or shouldn't do that. And it's likely that the company is in financial distress and possibly insolvent already. But that's something that needs to be explained, because if the restructuring plan doesn't get voted up, or the debtor in possession model doesn't get voted up by creditors, the proposal under that model, then there's ramifications for the company and the director after that process. It may then be pushed forward into liquidation, or there might be trading insolvent claims down the track. And the fact of this event back then may in fact make it a little bit easier for a registered liquidator to pursue those voidable transactions under the Corporations Act. But I think there's more benefit to directors than, so more positives than negatives when we're looking at this process, because one of the hardest things for directors, I find, when I'm advising them, is that handing over of control to a voluntary administrator under the Corporations Act. So this model, which is going to be available for those companies with less than $1 million in liabilities, is going to have that benefit of the director remaining in control, able to continue to trade, able to deal with both creditors and debtors of the company, and retain his or her position at the mast of the ship, so to speak. So that's something that's going to be really attractive to directors when they understand that, and I think that's going to be, I see that increasing the potential utilisation of these reforms. These reforms present the opportunity to adopt either simplified liquidation procedures or to pursue a restructuring proposal where the director retains some control throughout the process. And I think from a psychological perspective, that is going to be something that means a lot to a lot of small businesses.